I fear that we're losing that a little bit to the technology and to the bubble around technology. I just caution that doing things slowly and having the thinking time around doing things is actually a value add in many respects. The rush for efficiency and productivity without defining what those terms actually mean in the context of being a lawyer, I think is something that needs a slight halt before we let the horse bolt too far.
Welcome to the People in Legal podcast. This is the Law and Beyond show, talking about everything that is the expanding legal universe, that is law, technology, education and compliance, and academia. I'm your host, Chantal McNaught. I'm a PhD researcher, researching how lawyers can navigate the conflicts between law as a profession and law as a business. And I also author the fully automated luxury lawyer newsletter that you can find on LinkedIn. And today we have a special guest, Angus Murray. Angus is a partner and trademarks attorney at Irish Bentley Lawyers. He is also the co-founder and director of The Legal Forecast, a not-for-profit which is a community of law students and lawyers who are creative, entrepreneurially minded, and believe in challenging the status quo and reimagining the legal profession so that it better serves society at large. Welcome to the show, Angus.
Great to talk to you, Chantal. Thank you.
Oh, it's wonderful to have you on here. Now, we have been having a fabulous chat off air. How do you make all of these divergent interests or seemingly divergent interests converge within your day-to-day?
I think that it does seem from the outside like there's a lot going on. In my mind, these are all threads that come together and make a fabric that's coherent in my mind. And it probably goes back to me being a child at about 12 years old in a conversation I had with my grandmother in England about what I wanted to do with life and a career. And she planted seeds that she may be proud that she'd done. She may be proud that I've taken from those seeds to where I am now. I'm sure she's watching from somewhere with a smile on her face as I'm saying this. That sent me down a path of an interest in law generally. And as a 12-year-old, I must admit, I don't think I had a proper comprehension of what law actually was as a profession, let alone as a concept. But that took me to an undergraduate degree at the University of Southern Queensland, where I graduated after having completed a capstone project in the honours of the degree on the interaction between the personal right of privacy and a corporation's responsibilities vis-a-vis copyright infringement, and that was as a predictive analysis of what the High Court would determine in IONET and Roadshow Entertainment. You can probably tell just from that instant moment that I'm a bit of a nerd. I had an early interest in the internet, a very specific interest in intellectual property, and that decision, probably more than anything else, really refined a focus into what roles and responsibilities we have as humans to each other and what rights we have in that context of us in a society. That rabbit hole opened without me truly appreciating how deep it would be. I haven't found the bottom yet, but I jumped fully into that with a master's in law at Stockholm University, where I explored that question further as a comparative analysis between Australia and the European Union vis-a-vis the right to privacy and the enforcement of copyright. That got me back to Australia in 2013, bright-eyed, bushy-tailed, very, very interested in that intersection of technology, law, and human rights. In 2013, I don't think the conversation about technology, law, and human rights was anywhere near as loud or as pervasive as it is now. I'd say I just have the fortune, potentially, of the timing of an interest that started a little bit earlier than that. And from that, I've just expanded layers and threads built into that fabric, which are the roles and responsibilities we have and the human rights, which is a lot of the work that I do with the Queensland Council for Civil Liberties, informally and remaining to an extent with Electronic Frontiers Australia through the lens of digital rights. It's prompted me to keep writing academically about rights and responsibilities in law, particularly as it relates to technology. I found a very, very powerful, very motivated and very passionate group of people through the foundation of the Legal Forecast. Proudly, 10 years on, that organisation has given to me more connections, more motivation and more lenses of passionate people than anything else. It is a fantastic organisation comprised of some truly exceptional human beings. And over 10 years, it's amazing to see the various different paths that people have walked, and excellent to still be able to be connected to people who are starting their journey on their own paths. And then I run a professional practice alongside that, which I think is the key to it all, and that is commentary on the law. I think is valuable. Commentary while being in the law, I think, is more valuable. And I think it's important to weave some of these things together. My practice primarily being in intellectual property and administrative law. There are threads that come from the litigation of intellectual property and admin law that tie into, I think, some of these questions we're having about technology, and certainly the ability to be at the coalface of the legal profession in the courts, I think, is a more refined and grounded understanding of how ethics associated with technology is being applied, and where we might need to tweak or reinforce some of the ethical obligations we have as lawyers moving forward with these advanced technology tools that seem to now be pervasive across the profession.
What has sparked your interest so far? I know previously we talked about taxation and cryptocurrency, but I think you might have moved on about that. There might have been some kind of mention about a goatskin notebook. So what would you like to to talk about regarding what has gotten your interest of late?
Anything that's focused on something other than humans and is something other than human-centric in its design, I think is inherently going to have an issue at some point. I think there's plenty of examples where things have started out with all of the nice words and the nice sentiments around what's being done and very rapidly dissipated into something else. I think the key really is to keep humans at the front of the mind and the human benefit associated with anything that we're doing at the front of the mind as well. Humility in all things that we do, I think, is profoundly important as well. One of the challenges I think we have as lawyers is the balance, and I think you're doing some particularly important work here in terms of the challenge between the profession of law and the business of law, because one of the real difficult things about being a lawyer is that there is an element of it that's commercial. There's an element of it which is servitude to a justice system, and there's an element of it which is to brush up against things and to test things in a responsible and appropriate way, where it seems like the human element of something is being pushed too far in the wrong direction. One of the great benefits I have of working in law and having a team of very talented lawyers around me at Irish Bentley and the barristers that I have the opportunity to work with across a relatively wide subject matter range is each matter has its own nuanced complexities or difficulties in terms of how the law operates or how the client expects the law to operate or what the evidence is or how an opponent is approaching something. In each of those, I think it's just an exercise in meticulously navigating the situation that a person is facing and doing so with a solid grounding in the basic propositions of law in an area. Not getting lost to nuance, because that's how I think hyper focus on something can end up actually blurring and damaging a decision. But being able to map something through conceptually and then work through the intricacies of each step through the process, I think is really important. And in my experience, that is a common theme across different practice areas and different subject matters. It's not unique to one area. I think the art of being a lawyer is truly just the ability to digest information, absorb a situation, map a path through it, and understand where there's risks, responsibilities, and obligations through processes that unfold, and be able to do that in a way that treats a client with the dignity that a client should be treated with, the courts with the responsibilities and obligations that the court should be treated with, and the respect that should be towards the court, and the collegiality that should exist between colleagues, which are our opponents. And I think when all of that's put together, the practice of law is actually a fantastic endeavor. It gives an insight into people's lives, into businesses, into the fabric that makes us individuals comprised in a society and a society function. And I think that the truly profoundly important thing there is, again, the humans. It's all going to come back to the humans, I think, in every context.
Well, on that, I want to talk about a little bit. I want to find out from you what your opinion is regarding the bubble that Sam Altman said the quiet part out loud and said that there's potentially an AI bubble, and a lot of the attention and the conversation has now shifted because a lot of the corporations that have laid off people have said, well, I'm going to get AI to do it, where all of those sorts of concerns, valid concerns that people had around their employment opportunities and stability has gone by the wayside because we put computers first. What's your take on all of that?
I use an anecdote of a paginator whenever I have this conversation or something along this, and that is, um, I have now, with the advantage of time, very fond memories of a paginator. I certainly have fond memories of um, Pat Noonan, who was the principal of the firm that I was working at when I was first exposed to a paginator. And Pat was an excellent mentor and a very, very brilliant lawyer at Cleary and Lee in Toowoomba. The paginator, when I first got exposed to it, was an extremely tedious, monotonous, horribly clunky, in every sense of the word, clunky piece of equipment used to put numbers at the bottom of pages. It was a very specific way of doing that, and it required inking, and there's certainly a lot of experiences I've had brushing ink or wiping ink off certain things, hands and shirts, because getting that right was an art in itself. I didn't really appreciate the paginator until the paginator stopped working or we ran out of ink, and then it was a pen writing numbers at the bottom of a page. Uh, that I think is a profoundly important part of what law is in a number of different dimensions. I don't think a paginator will ever theme again in legal practice. I think Adobe completely wiped out that particular role. Good, let that be gone. That should be redundant. That's a
Or
positive technology.
photocopying software.
Photocopying, faxing, there's a whole heap of things which are now relics of the past. What shouldn't be lost to the past is the skills that came from paginating, and that's not the ability to stick a number at the bottom of a page in precisely the right place, repetitively, several hundred, if not thousand times. Let Adobe take that. But the ability to scan through thousands of pages of material, most of which is either not going to be directly relevant or is at least incredibly boring in terms of going through material. The lessons that come out of that are, in my view, the ability to do something that requires concentration and attention to detail over and over again for an extended period of time. I think that the attention economy that we've moved into and the need to do things instantaneously is potentially a detractor from some of the what I'd call fundamental skills of lawyers. The other aspect to it is the ability to do something monotonously and with care. And I appreciate attention to detail is one side of that. But the care aspect of it, I think, is important too. The pride in doing something and producing something yourself, I think, is somewhat being lost to some of these technologies. And then more fundamentally, and probably the most important aspect of it, is the ability to appreciate that law is not 100% glamour and glory and time in court and all the things that make the drive for why I continue to practice law. If it wasn't for the courts, I would really struggle. I think that the rush of being in a courtroom and the argument and the ability to put submissions together is what drives me. If you can't appreciate and these are arbitrary numbers, 90% of the job, which is boring or mundane or has some things that I'm sure could be levied a lot of criticism around how unnecessary large parts of it seem to be, then the 10% isn't possible because those parts very rapidly become necessary and important when you get to the pointy end of law. I fear that we're losing that a little bit to the technology and to the bubble around technology. I just caution that doing things slowly and having the thinking time around doing things is actually a value add in many respects. The rush for efficiency and productivity without defining what those terms actually mean in the context of being a lawyer, I think is something that needs a slight halt before we let the horse bolt too far. And to your question, that horse bolts too far when you deprive graduates the ability to appreciate those lessons.
I wholeheartedly agree that any organisation seeking to replace juniors, those that are at the beginning of their careers in a professional service, are most likely ringing their own death bell, because the future is always going to be human, and the future of whatever your specialization, professional expertise will rely on your succession planning, and that succession planning ultimately has to serve people, and people must be involved in that. I really wanted to, like, something that struck me from what you just said as well was about slowing down, because I think this ties into that whole AI hallucination thing that's caught the zeitgeist on our LinkedIn feeds too, about this concept of lawyers submitting to the court, and I don't want to call it hallucinated cases because you know my opinion about the term hallucination. So like made up case citations that have not been actually adequately looked at. Something you told me off air was around how it's a similar sort of situation when it comes to previously with the head notes and lawyers relying on head notes instead of actually doing the slow thing and looking through the analysis and actually pinpointing whether that case actually has a principle that's relevant to the case. So I don't know if there's a question in this. I just want to see if your response.
There is a question there. There's probably several, and at least a couple of them are probably existential to the ongoing practice.
Oh yeah, that's on theme for me then.
The existential issue, I won't say it's a threat because it may be a reality, is if technology is going to legitimately replace lawyers, and I agree with you, I don't think that's the case. I think the lawyerly answer of there's a middle ground and the middle ground is the appropriate ground is correct. To the extent that there's a replacement of functions of lawyers, the important thing that follows from that is the cost that lawyers apply to their services. If something is being done by a computer program, in my view, the most that can be charged is a supervision of a program that is then the license fee passed on to the client. I don't think that that's what people come to lawyers for. There might be a space for that kind of practice, and certainly there are firms that are, I think, already moving to that space. That isn't to say that they shouldn't be doing that, but that isn't the totality of what I think law will be in the future. The converse to that is taking things slowly doesn't mean gouging clients. It means affording a client the justice that they deserve in the time spent and the consideration and the care taken in their matter. Using a head note and citing a case as a proposition without understanding what the decision stands for, or checking whether it's been appealed or distinguished in other senses, or whether it's even applicable to the proposition in law that's contained in the submission, I think is what our job fundamentally is. Any shortcut around that, I think, falls foul, and I think that's what we're starting to see in the courts now. The problem with shortcuts, I think, and I know you've used an analogy a number of times about calculators, which isn't perfect, but I'll use it again anyway. The problem with using shortcuts is you have to understand the long form before you can do the short form. So if you take the calculator, we as subject matter experts in law are like mathematicians in a very rudimentary sense. I know 1 + 1 = 2, not because I have that function taught to me, but because I can conceptualize what 2 is and how 1 + 1 has equaled 2. If I was taught only ever how to enter or push the button that looks like 1 at the top left-hand corner, then the plus button, the long rectangle, and then the little equals thing at the bottom, and it spat out 3 with no analog background to what 1 + 1 is, there's no reason why 3 is the wrong answer. I'd have no intuition on that. The same kind of thing happens with hallucinated cases. I think if you're relying on something to make a proposition in a submission where you can't intuit that that's something that's wrong, or at least something you haven't seen before, I think that's where the concern really sits. That's an education fix. That's not a technology fix. The responsibility and the buck stops on the lawyer, and it always will. I don't think there will be a situation where we can properly and legitimately sue technology or a personality in artificial intelligence. And that's an existential question, potentially, that's a bigger rabbit hole.
A lot of people have come to me saying, oh, not many people are talking about the price and value issue when it comes to AI's impacts of legal service and what that's going to do with the billable hour. But it's actually something that I must be in this world because I've seen a lot of people talk about it. But it then the important part of that conversation is the billable hour going to die? And you pointed to a very important part about there are some things where being slow is smooth, and smooth is the accurate way that helps make things go fast. It ensures the adequate justice for clients and society. It's not necessarily a thing about time. It's actually a thing about value. And lawyers are legal profession is starting to get into this modality of thinking about, well, what is the value that lawyers provide society? And that excites me, because that, I think, is the big crux of the professionalism and the commercialism, because at the end of the day, that's the tension, or one of the tensions that is seen in there.
And if I can just pick up on that in a very abstract sense, I'm the first lawyer in my family on both my father and my mother's side, so I'm a black sheep in some and many respects. There's an interesting proposition about what lawyers are to society that I quite like, and this is an almost stoic form of thinking, and that is the fastest way to see a society crumble is the garbage man stopping picking up garbage. The function of a garbage man, in many respects, is more valuable to society than lawyers, and I think that humility is necessary in the process of being a lawyer, that the practicing a profession as a servant to society, as opposed to some form of grandiose, ego-driven, which is tempting as lawyers. I think that there's an arrogance that comes out of advocacy and of our adversarial system that is necessary. But I think the humility and the humble understanding that we are servants to a system is really, really important. And I think that ties into the costing, because I think if you're seeing yourself in that, and this is, I think, bang on point with your PhD, if you see yourself as a lawyer first before a business person, I think you get to a different outcome than it's a business of lawyers. They're both necessary, and that balance, I think, will perpetually be a difficult feat to hit in the middle. Law is inherently slow. I think the start of this was probably the early 2000s, with the discussion in the UK, and then spilled over to here about a new act to regulate lawyers. And in that act in the UK, alternate legal services, and in Australia, independent incorporated legal services, multiple disciplinary practices. Richard Susskind described that as the liberalisation, and I think that concept of liberalisation meeting the more for less challenge, which Susskind talked about quite a while ago, I think was on point. I think that we're just slow to pick up the consequence of those issues, but I don't think anything in that particularly changes the 500-600 years in our common law tradition before that point. I think it's been fairly clear through the courts that what we are as lawyers hasn't changed. The mode that we operate and the manner that we operate might change, but what we are as lawyers existentially, I think, remains the same. And I fear, in some respects, people coming into practice without a really passionate interest in jurisprudence, and probably jurisprudence as well as more broad philosophy, because I think that question of what I am and why I am as a lawyer, I think it's a really important part of the innate traits that a lawyer should have, and a part of the unconscious thinkings and the unconscious operation of a lawyer is to have those existential philosophical groundings in what we're doing, rather than focusing on how much we're operating as a profession. And if we were to lose that, I think that's a fundamentally difficult question to grapple with, because I think with that goes the profession.
Whoa. And with that very existential and deep thinking, which I obviously really appreciate, but it is now time for our conversation cards, a random selection of conversation topics to ask the guest. And I'm going to hold the cards up here so everybody who watches the YouTube video can see how terrible I am at shuffling, and you can hear the microphone so you can hear how terrible I am. And perfectly random. Angus, what's the best gift that you've ever received?
That's an interesting question. I'll give two answers to that. The best gift, I think, is quality time. So not in a physical or material sense. I think the gift of presence with another person is my absolute favourite form of gift. I'm not a particularly materialistic person, and I don't have a particularly large interest or appetite for commercialism. So time and quality time with another person, I think, is a good place to be. Well, the best gift in a material sense was an incredibly random, and this is a very random story that involves my wife and our time in Sweden. And it was Christmas, and this is probably not a story that will resonate with everyone, but I'll tell it anyway. In Sweden at Christmas, I was at the end of the day in the university writing and meeting up with my wife Crystal and a couple of friends in Gamlestan, the old town in Stockholm. And Crystal came over to me and said, I bought you a present. I said, I don't particularly need presents or like presents. And she said, no, you like this. It's a triple smoked reindeer heart. And it was delicious, and it was a completely random thing to have, completely out of the blue. And it was, I think, in that moment, possibly in a weird way, one of the most romantic and best gifts I think I could have ever received. But no, I think the quality time is the key point of that, if it's not a reindeer heart.
I really do appreciate it. This has been the Law and Beyond show on the People and Legal podcast. If you enjoyed the show, please consider leaving a review, as it helps others find the show, and see you next time.